acting with criminal negligence. Criminal negligence means that a person acts with criminal negligence when the person ought to be aware of a substantial and justifiable risk that the alleged victim would be killed. The risk must be of such a nature and degree that his failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances is viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown that the defendant acts intentionally, knowingly, or recklessly. Intentionally has previously been defined. Has been previously defined for you on page 13 of the instruction. Knowingly has been previously defined for you on page 17 of the instruction. Recklessly has been previously defined for you on page 19 of the instruction. If you find from the proof beyond reasonable doubt that the defendant is guilty of criminal negligence or homicide, you may fix a fine in any amount not greater than $3,000 and will so report your fine on your verdict form. If you have reasonable doubt that the defendant is guilty of criminally negligent homicide,
I think the jury is getting the case.
Must be not guilty of this count. Lesser included offense counts 1, 2, and 4. Child abuse. Any person who commits child abuse is guilty of a crime. For you to find the defendant guilty of this offense, they must have proven beyond reasonable doubt that this the following essential elements. 1, if the defendant knowingly, other than by accidental means, treated the child in such a manner as to inflict injury. And 2, if the child was 8 years of age or less. Knowingly has been previously defined for you on page 15 of these instructions. The requirement of knowingly is also established to be shown that the defendant acted intentionally. Intentionally has been previously defined for you on page 15 of these instructions. Child and bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond reasonable doubt that the defendant is guilty of child abuse, you may fix a fine in any amount not greater than $2,500. You so report your fine on your verdict form. If you have reasonable doubt that the defendant is guilty of child abuse is charged in the presentment, then your verdict must be not guilty of this offense. Lesser included offense counts 1, 3, and 5. Child neglect. Any person who commits child neglect is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly neglected the child so as to adversely affect the child's health and welfare. And 2, that the child was 8 years of age or less. Knowingly has been previously defined for you on page 15 of the instructions. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally has been previously defined for you on page 15 of these instructions. Child and bodily injury are defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. If you find from the proof beyond reasonable doubt that the defendant is guilty of child neglect, and you may fix a fine in any amount not greater than $2,500, you also report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of child neglect is charged in the presentment, then your verdict must be not guilty of this offense. Count 4, aggravated child abuse. Any person who commits the offense of aggravated child abuse is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond reasonable doubt that this is the following essential elements. 1, that the defendant knowingly, other than by accidental means, treated a child in such a manner as to inflict injury. And 2, that the act of abuse resulted in serious bodily injury to the child. And 3, that the child was 8 years of age or less. Knowingly has been previously defined for you on page 15 of these instructions. The requirement of knowingly is also established for you shown that the defendant acted intentionally. Intentionally has been previously defined for you on page 15 of these instructions. Child and serious bodily injury are defined for you in the definition section of these instructions. The requirement of knowingly is also established for you shown that the defendant acted intentionally. If you find from the proof beyond reasonable doubt that the defendant is guilty of aggravated child abuse, then you may fix a fine in any amount not greater than $50,000 and so report your fine on the verdict form. If you have a reasonable doubt that the defendant's guilty of aggravated child abuse is charged in the presentment, then your verdict must be not guilty of this offense. This included offense counts 4 and 5, aggravated assault. Any person who commits the offense of aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond reasonable doubt the existence of the following essential elements. 1, that the defendant intentionally or knowingly caused bodily injury to another, and 2, that the act resulted in serious bodily injury. For purposes of this count, intentionally knowingly bodily injury and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated assault, then you may fix a fine in any amount not greater than $10,000. You'll also report your fine on your verdict form. Excuse me. If you have reasonable doubt that the defendant is guilty of aggravated assault, is charged and presented, then your verdict must be not guilty as to this offense. Lesser included offense counts 4 and 5, reckless aggravated assault. Any person who commits the offense of reckless aggravated assault is guilty of the crime. For you to find the defendant guilty of this offense, the state must prove beyond reasonable doubt the existence of the following essential elements. 1, the defendant recklessly caused bodily injury to another, and 2, that the act resulted in serious bodily injury. For the purpose of this count, recklessly bodily injury and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond reasonable doubt that the defendant is guilty of reckless aggravated assault, then you may fix the fine in any amount not greater than $10,000. Sorry, not greater than $5,000. You also report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of reckless aggravated assault is charged and presented, then the verdict must be not guilty to this offense. Ladies and gentlemen, anytime that I make a change, I'm making a change in the no witness file. It says original charge. This is the official original charge. Those are just copies. Okay. Lesser included offense counts 1, 2, 3, 4, and 5. Assault. Any person who commits an assault upon another is guilty of a crime. If you find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant caused bodily injury to another, and 2, that the defendant acted either intentionally, knowingly, or recklessly. For purposes of this count, intentionally, knowingly, recklessly, and bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of assault, you may fix the fine in any amount not greater than $2,500. You also report your fine on the verdict form. If you have reasonable doubt that the defendant's guilt of assault is charged in the presumption, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, 3, 4, and 5. Misdemeanor, reckless endangerment. Any person who commits the offense of misdemeanor, reckless endangerment is guilty of a crime. If you find the defendant guilty of this offense, they must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant engaged in conduct which placed or might have placed another person in imminent danger of death, serious bodily injury, and 2, that the defendant acted recklessly. For the threat of death or serious bodily injury to be imminent, the person must be placed in a reasonable probability of danger as opposed to a mere possibility of danger. Before you can convict the defendant, the state must show beyond reasonable doubt that a person or class of persons is in the zone of danger. The zone of danger is that area in which a reasonable probability exists that the defendant's conduct would place others in imminent danger of death or serious bodily injury. For purposes of this count, recklessly, intentionally, knowingly, and serious bodily injury are defined for you in the definition section of these instructions. The requirement of recklessly is also established and shown within acting intentionally or knowing. If you find from the proof beyond a reasonable doubt that the defendant is guilty of misdemeanor reckless endangerment, then you may fix the fine in any amount not greater than $3,000. So, $2,500. You also report your fine on your verdict form. If you have reasonable doubt that the defendant is guilty of misdemeanor reckless endangerment is charged and presented, then the verdict must be not guilty to this offense. Count 5, aggravated child neglect. Any person who commits the offense of aggravated child neglect is guilty of the crime. If you find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly neglected the child so as to adversely affect the child's health and welfare. And 2, that the act of neglect resulted in serious bodily injury to the child. And 3, that the child is 8 years of age or less. Knowingly has been previously defined for you on page 15 of these instructions. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally has been previously defined for you on page 15 of these instructions. Adversely affect the child's health and welfare, child, and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated child abuse, you may fix the fine in any amount not greater than $50,000 and so report your fine on the verdict form. That should save the delay. find from the proof beyond reasonable doubt that the defendant is guilty of aggravated child neglect, then you may fix the fine in any amount not greater than $50,000 and so report your finding in verdict form. If you have a reasonable doubt as to the defendant's guilt of aggravated child neglect is charged and presented, then your verdict must be not guilty to this offense. Count 6, tampering with evidence. Any person who commits the offense of tampering with evidence is guilty of a crime. If you find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant knew an investigation was in progress, and two, that the defendant concealed the thing with the intent to impair its availability as evidence in the investigation. For purposes of this count, knew, conceal, destroy, and bodily injury are defined for you in the definition section of these instructions.
The jury's getting the case, guys.
The requirement of knowing is also established to be shown that the act intentionally. If you find from the proof that a reasonable doubt that the defendant is guilty of tampering with evidence, then you may fix the fine in any amount not greater than $10,000. You'll also report your fine on your verdict form. If you have a reasonable doubt that the defendant is guilty of tampering with evidence, the charge and presented, then your verdict must be not guilty to this offense. Count 7 through 17, false report. Any person who makes a false statement to law enforcement officers is guilty of a crime. If you find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the statement was made by the defendant. Two, that the statement was made in response to a legitimate inquiry by a law enforcement officer. And three, that the statement would concern a material fact about an incident within the officer's concern. And four, that the defendant knew such statement was false. And five, that the statement was made by the defendant with the intent to obstruct or hinder the officer from preventing an incident from continuing to occur. For purposes of this count, new and law enforcement officer are defined from the definition section of these instructions. The requirement of knowing is also established for the showing defendant acted intentionally. If you find from the proof beyond reasonable doubt that the defendant is guilty of false report, you may fix a fine in any amount not greater than $5,000 and so report your fine on the verdict form. If you have reasonable doubt that the defendant's guilt of false report is charged and presented, then the verdict must be not guilty to this offense. Count 19, abuse of a corpse. Any person who commits the offense of abuse of a corpse is guilty of a crime. For you to find the defendant guilty of this offense, they must have proven beyond reasonable doubt the existence of the following essential elements. One, that the defendant physically mistreated the corpse in a manner offensive to the sensibilities of an ordinary person. And two, that the defendant acted without legal privilege. And three, that the defendant acted knowingly. For purposes of this count, knowingly is defined for you in the definition section of these instructions. The requirement of knowingly is also established for the shown in the defendant acted intentionally. If you find from the proof beyond reasonable doubt that the defendant is guilty of abuse of corpse, then you may fix a fine in any amount not greater than $3,000. You also report your fine on the verdict form. If you have reasonable doubt as to the defendant's guilt of abuse of corpse, the charge will be presented and the verdict must be not guilty to this offense. Count 20. Failure to report a death under suspicious, unusual, or unnatural circumstances. Any person who commits the offense of failure to report a death under suspicious, unusual, or unnatural circumstances is guilty of a crime. If you find the defendant guilty of this offense, the state must have proven beyond reasonable doubt the existence of the following essential elements. One, that the defendant knowingly failed to report the death of Megan Boswell to the county medical examiner, local police, district attorney, or sheriff. And two, that the death was from violence, trauma, or suspicious, unusual, or unnatural manner. For purposes of this count, knowingly is defined for you in the definition section of these instructions. The requirement of knowingly is also established for the showing defendant acted intentionally. If you find from the proof beyond reasonable doubt that the defendant is guilty of failure to report a death under suspicious, unusual, or unnatural circumstances, then you may fix a fine in any amount not greater than $3,000, and you'll so report your fine on the verdict form. If you have reasonable doubt as to the defendant's guilt of failure to report a death under suspicious, unusual, or unnatural circumstances, as charged in the presentment, then your verdict must be not guilty to this offense. Criminal intent. The following definition applies to the attempt to commit any criminal offense that is charged or included as a lesser offense in these instructions. Any person who attempts to commit any criminal offense is guilty of a crime. For you to find the person guilty of criminal attempt to commit any criminal offense, the state must have proven beyond reasonable doubt the existence of the following essential elements. One, that the defendant intended to commit a specified criminal offense, and two, that the defendant did some act intended to complete a course of action or cause result of a constitutional specified criminal offense under circumstances as the defendant believed them to be at the time. His actions constitute a substantial step for the commission of the specified criminal offense. The defendant's actions do not constitute a substantial step unless the defendant's entire course of action clearly shows his intent to commit the specified criminal offense. The essential elements necessary to constitute each specified criminal offense are set out in these instructions. The definition of attempt to commit a criminal offense and the fine associated with each attempt to commit a criminal offense is as follows. Count 1. Attempt to commit premeditated first degree murder, maximum fine $50,000. Attempt to commit second degree murder, maximum fine $50,000. Attempt to commit voluntary manslaughter, maximum fine $50,000. Attempt to commit child abuse, maximum fine $50. Attempt to commit child neglect, maximum fine attempt to commit child abuse, maximum fine $500. Attempt to commit child neglect, maximum fine $500. Attempt to commit assault, maximum fine $500. Count 2. Attempt to commit first degree murder and perpetration of a felony, maximum fine $50,000. Attempt to commit second degree murder, maximum fine.
The judge is giving the case to the jury, and he's going over jury instructions right now.
Attempt to commit child abuse, maximum fine $500. Attempt to commit assault, maximum fine $500. Count 3. Attempt to commit first degree murder, perpetration of a felony, maximum fine $50,000. Attempt to commit second degree murder, maximum fine $25,000. Attempt to commit voluntary manslaughter, maximum fine $5,000. Attempt to commit child neglect, maximum fine $500. Attempt to commit assault, maximum fine $500. Count 4. Attempt to commit aggravated child abuse, maximum fine $25,000. Attempt to commit aggravated assault, maximum fine $5,000. Attempt to commit assault, maximum fine $500. Attempt to commit child abuse, maximum fine $500. Count 5. Attempt to commit aggravated child neglect, maximum fine $25,000. Attempt to commit aggravated assault, maximum fine $5,000. Attempt to commit assault, maximum fine $500. Attempt to commit child neglect, maximum fine $500. Count 6. Attempt to commit tampering with evidence, maximum fine $5,000. Counts 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17. Attempt to commit false report, maximum fine $5,000. Count 19. Attempt to commit abuse of corpse, maximum fine $2,500. Count 20. Attempt to commit failure to report death under suspicious, unusual, or unnatural circumstances, maximum fine $2,500. Facilitation of a felony. The following definition applies to any offense of facilitation that is charged or included as a lesser offense in these instructions. Any person who commits the offense of facilitation of a felony is guilty of a crime. If you find the defendant guilty of facilitation of any offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1. That the defendant knew that another person intended to commit a specified offense, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense. And 2. That the defendant furnished substantial assistance to that person in the commission of the specified criminal offense. And 3. That the defendant furnished such assistance knowingly. The essential elements necessary to constitute the specified criminal offense are set out in these instructions. The definition of facilitation of an offense and the fine associated with each facilitation offense is as follows. Count 1. Facilitation of first degree murder, maximum fine $50,000. Facilitation of attempt to commit first degree murder, maximum fine $25,000. Facilitation of second degree murder, maximum fine $25,000. Facilitation of attempt to commit second degree murder, maximum fine $10,000. Facilitation of voluntary manslaughter, maximum fine $5,000. Facilitation of attempt to commit voluntary manslaughter, maximum fine $3,000. Facilitation of reckless homicide, maximum fine $3,000. Facilitation of criminal negligent homicide, maximum fine $2,500. Count 2. Facilitation of first degree murder and perpetration of a felony, maximum fine $50,000. Facilitation of attempt to commit first degree murder and perpetration of a felony, maximum fine $25,000. Facilitation of second degree murder, maximum fine $25,000. Facilitation of attempt to commit second degree murder, maximum fine $10,000. Facilitation of voluntary manslaughter, maximum fine $5,000. Facilitation of attempt to commit voluntary manslaughter, maximum fine $3,000. Facilitation of reckless homicide, maximum fine $3,000. Facilitation of criminal negligence homicide, maximum fine $2,500. Count 3, facilitation of first-degree murder and perpetration of felony, maximum fine $50,000. Facilitation of intent to commit first-degree murder and perpetration of felony, maximum fine $25,000. Facilitation of second-degree murder, maximum fine $25,000. Facilitation of attempt to commit second-degree murder, maximum fine $10,000. Facilitation of voluntary manslaughter, maximum fine $5,000. Facilitation of attempt to commit voluntary manslaughter, maximum fine $3,000. Facilitation of reckless homicide, maximum fine $3,000. Facilitation of criminal national homicide, maximum fine $2,500. Count 4.
Working like a field day, hit 'em with a freeze frame, feeling like a movie, catch 'em on the replay, flash them lights all on.
Maximum fine $3,000. Facilitation of aggravated assault, maximum fine $5,000. Facilitation of attempt to commit aggravated assault, maximum fine $3,000. Facilitation of reckless aggravated assault, maximum fine $3,000. Count 5. Facilitation of aggravated child neglect, maximum fine $5,000. Facilitation of attempt to commit aggravated child neglect, maximum fine $3,000. Facilitation of aggravated assault, maximum fine $5,000. Facilitation of attempt to commit aggravated assault, maximum fine $3,000. Facilitation of reckless aggravated assault, maximum fine $3,000. Count 6. Facilitation of tampering with evidence, maximum fine $5,000. Facilitation of attempt to commit tampering with evidence, maximum fine $3,000. Count 19. Facilitation of abuse of courts, maximum fine $2,500. Criminal responsibility for conduct of another. The defendant is criminally responsible as a party to the offense charged and including if the offense was committed by the defendant's own conduct or the conduct of another for which the defendant is criminally responsible or by both. Each party to the offense may be charged with the commission of the offense. The defendant is criminally responsible for an offense committed by the conduct of another if, acting with the intent to promote or assist the commission of the offense or the benefit and proceed the result of the offense, the defendant solicits, directs, aids, or attempts to aid another person to commit the offense. Under the theory of criminal responsibility, an individual's presence and companionship with the perpetrator of an offense before and after commission of an offense or circumstances from which his or her participation in the crime may be inferred. No particular act can be shown, and the defendant need not have taken a physical part in the crime in order to be held criminally responsible. However, a defendant's mere presence during the commission of a crime is not enough to convict based on the theory of criminal responsibility for the conduct of another. The jury is not required to make this inference. It is the exclusive province of the jury to determine whether the facts and circumstances shown by all the evidence in the case warrant the inference which the law permits the jury to draw. The inference may be related by direct or circumstantial evidence or both, whether it exists in the evidence of the state or the evidence of the defendant. Before you can find the defendant guilty of being criminally responsible for an offense committed by the conduct of another, you must find that all the essential elements of the offense have been proven by the state beyond reasonable doubt. Definitions. Intentionally or intent means a person acts intentionally with respect to the nature of the conduct or the result of the conduct when it is the person's conscious subjective desire to engage in the conduct that cause the result. Knowingly or knew means that a person acts knowingly with respect to the conduct or the circumstances surrounding the conduct when the person is aware of the nature of the conduct or the circumstances exist. The person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowing is also established to be shown to defendant acting intentionally. Recklessly or reckless means that a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct when the person is aware of the conscious disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must give such a nature and degree that its disregard constitutes a gross deviation from the standard of care that the ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessness is also established to be shown the defendant acting intentionally, not adversely affect the child's health and welfare